Welcome to Leveraging Inspiration, the Inspired Patent Podcast, where we help you understand and leverage your intellectual property. I'm your host, Wayne Carroll, and I'm excited to bring you insights and stories from the success and failures of others and teach you how to win at the game of intellectual property. I always start with the disclaimer. The information I provide on this podcast is for educational and informational purposes only. I am not providing legal advice, and nothing in this podcast should be construed as creating an attorney-client relationship. This week, we're talking about copyrights, and today in this episode, we're going to talk about qualifications for copyright ownership, ChatGPT, and OpenAI. So as background, in 2011, a monkey in Indonesia took a selfie using a photographer's camera. The photographer, David Slater, claimed copyright ownership of the photo and published it. However, animal rights group PETA filed a lawsuit on behalf of the monkey, arguing that it should hold the copyright since the monkey took the photo. The court ultimately rejected PETA's argument, ruling that animals cannot own copyright under U.S. law. The court found that copyright law only applies to, quote, human authorship, and therefore only humans can hold copyright ownership. So this ruling has set a precedent for future cases involving non-human creations. Small business owners need to understand how intellectual property works, including copyright ownership qualifications, to ensure they do not infringe on the rights of others and to protect their own creations. To qualify for copyright ownership, a work must be original and fixed in a tangible medium of expression. That means something you can touch, hold, like a hard drive, or a piece of paper, or a photograph, or a framed painting. So the creator or owner of the work can be an individual or a legal entity, such as a corporation. Additionally, it is important to note that non-human entities, such as animals or AI, are not currently recognized as copyright owners under U.S. law. So as a small business owner, it is important to ensure that any work you use or create does not infringe on the copyright of others. This includes obtaining permission or licensing for any copyrighted material you use. And of course, you want to register anything that is valuable in your business. So one of the things that is going on right now is ChatGPT and AI. There have been some cases that they're really in progress right now. The first set of cases is the question of whether AI is allowed to train on other people's copyrighted works. Do they need permission to basically scrape the internet and learn and train their computer based on everybody else's content? Do they need a license from everybody? So there are some lawsuits. Getty Images, as I mentioned before in a previous podcast, is the largest licensor of commercial images around the world. So they have probably millions, I don't know the number, but at least millions of images. And Getty Images has filed a lawsuit claiming that by training an AI, and their AI that will make or draw pictures, create images, combine things, and basically make a new image that didn't exist before. But what they say is it's using their copyrighted works as training. They made a copy in a sense by training an AI, and that AI in a sense is making a derivative work. Now it's really hard to figure out how this is all going to shake out, but it is a major risk. And perhaps these AI models, they'll have enough money, they'll just license from Getty Images and therefore have the ability to train their AI on their millions of images and then pay Getty money for producing images. Hard to know exactly how this is going to shake out, but that's one of the things going on. And So there's some other lawsuits that are similar to that are happening, that where people that have created content, they say an AI has used that and it's been learning based on their content, and they should receive compensation for that, or the AI has to, I mean, it's going to be hard to take that away from the AI. You kind of have to delete it and reset it back to before it had that content. So that's not very practical. So a second set of cases is around ownership of the AI produced content. And how it's coming out so far is that the Copyright Office will grant you a copyright, but you're going to have to clarify what part the AI created and what part you created. So this is tricky, and if you're using AI to create content that you later want to sell, you really need to be tracking what was your input. And oftentimes it's very iterative. You're going back and forth, you're inputting something, you're saying, no, let's adjust that. You input something else, and you just keep working with the AI over and over. And so somehow logging, recording that input so that it can be shown, and but it's not a bright line of here's how much the AI created and here's how much I created. You can just kind of show, here was my input and here's the final result. And so somewhere in between is what the AI created. But for right now, the Copyright Office will register a work that's created in part by AI, but you have to disclaim the AI part so that whatever that part is considered in the public domain, because there is no copyright at this point on AI created art or anything that gets copyright, whether it's a novel, sculpture, all kinds of things. So there's been a few different cases where people have attempted to register copyrights. Images are really where it gets interesting, because AI can create images based on your prompts. So those are a few things that come up with ownership of AI. And if you missed last episode, go back and listen to that, where I talk a lot about copying. If you copy even part of somebody else's work, then you may be infringing that person's work. And so it's this tough question of, is AI copying? Essentially, it's compiling millions of bits of data and coming out with something. And the argument is, isn't that what all artists do? When somebody writes a novel, they're gathering information that they've obtained throughout a lifetime, all kinds of things they've read, their vocabulary, the stories and plots that they've heard before. They're all coming together in that person's mind to create what is considered original. And so those arguments, I'm sure, are going to be made in court. But for right now, if you're using AI to create content, you are required to disclose that to the Copyright Office and have a disclaimer in there so that you don't get that copyright coverage. And of course, if your dog takes a picture, you're not going to get a copyright for it because the dog took the picture. And that's what happened in the monkey case. The monkey actually stole the camera and went around the jungle taking pictures. And the one picture is the monkey takes a picture of itself smiling. That one went viral. Now, ironically, the author self-published a book with these photographs in them, And he said he only sold 100 copies. So he didn't make money off of this hardly at all. But he became famous based on this. But now the courts have said, no, you can't. You don't own the copyright because the person behind the camera is who owns the copyright. Now, they did distinguish that if he had set it up, if he had created the scene and created the environment, maybe, and then basically coached the monkey to take that picture, that might have been different. But that wasn't the case. And sometimes courts go down this road of, well, if this and if that, that's called dicta in cases. So it doesn't really mean anything. They just sometimes go off of, well, this didn't happen. And if it did, it might be a different case, but we don't know because it didn't happen. So the question is still out there. Is AI copying? And if you're using AI produced content, is there a risk that you are using something that doesn't have a solid copyright or even potentially infringes on somebody else's copyright? So copyright law can get sticky. And of course, what Getty Images wants is for everybody to say, okay, we're not going to try to create our own images. We're just going to license these images from Getty or other artists, but they're the biggest suppliers. So if the market goes that way and doesn't go to AI, then they win. And of course, if everybody starts creating based on these AI and doesn't go to Getty because AI's, you tell it exactly what you want, that's what shows up in the picture, perfect, no searching, just it's done. That I'm sure will hurt Getty. So they're potentially fighting for their survival. But it's to be seen what's going to happen. AI is so young and so new that we don't know. So if you have any questions, go ahead and send them to me. I might be able to address them in a future episode. Or if you want to discuss your specific legal matters, go ahead and give me a call and we'll have a consultation for free. I'm Wayne Carroll with Leveraging Inspiration. Thanks for joining me.